1 second. Okay. Looks like we're live everywhere now. Welcome to Notable Approvals. I am Attorney Amanda Shaffer. Before we get to our case today, quick reminder, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video to be helpful or know someone who may, hit that share button, hit that save button, and drop us a comment. Let us know what you like. All right. So, I'm excited about today's case. We've been waiting a long time for this one. Client is a native and citizen of Canada. He entered the U.S. Not the first time, but the relevant time in 2018 in order to do an exchange program as a physician/research scholar. And his J-1 was extended until 2023. Prior to that, he met and married a U.S. citizen, and they met in 2017. They moved together upstate, and he proposed in 2020. They wed in 2021, and she was pregnant, and they had their first child back in January of 2023. Problem was that on the J-1, and not all J-1s have this requirement, the doctor was subject to the INA Section 212E requirement, also known as the 2-year home residency requirement, which means that unless he obtains a waiver, he cannot change his status or adjust his status in the U.S. without returning to his country for 2 years. Now, he had just finished medical school and his residency and was ready to start being a doctor. So what can we do? Now, I've talked about J-1 waivers here before. The most common are no objection waivers, where you basically ask your country, hey, do you have a problem with me staying instead of coming back? Because the idea is you get your skills in the U.S., go back and use your skills in your country. But doctors, they are not eligible for no objection waivers. So there are other types of waivers available, but they're a lot harder to get and take a lot longer. So the waiver that this client was eligible for was the Extreme Hardship Waiver. And we had to show an extreme hardship to his qualifying relative, which was his U.S. citizen wife, because his child was not born when we filed this all the way back in October 2022, which, if you're doing the math, you might say, well, that's not that much further away than the 2 years you were talking about that he would have been waiting, because it's already June 2022, and you would be right. However, I'll explain how all of that works. So, in order to qualify for the extreme hardship waiver on a J-1, similar to an extreme hardship waiver for those 601s or 601A waivers, you have to show both that your U.S. citizen or qualifying relative will suffer an extreme hardship if they stay in the U.S. without you, and if they go back to your country with you. So you have to show all of that, or you don't even have a chance to get approved. And these are very difficult to get approved. So in this case, part 1, we showed that she couldn't stay in the U.S. without her husband. First, we looked at financial reasons. They were about to have a baby, and she would have to effectively raise the child alone for 2 years. And her family, although U.S. citizens, did not live nearby. The expenses for the couple would double effectively, because he would have to go back to Canada and get an apartment, and she would have to stay here. And he would lose his income as a doctor. He already passed the boards. He was qualified to practice medicine in the U.S., had a job lined up as well. But if he went back to Canada, they did not accept his education and his license. So he would actually need to take 3 more years of school before he could practice medicine in Canada. And his employer in the U.S. that we had lined up also offered to sponsor him on an H-1B. Now, one thing to just keep in mind that there is a difference here. There are sometimes differences depending on what country you're from, especially Canada. Canada is a difference here. For any other country, if you're filing a J-1 waiver as a doctor, or a J-1 waiver in general, you cannot start an H-1B job until your waiver is approved. In this situation, because he was a Canadian, there's a special rule that he was actually allowed to. So he did have to go through the lottery process. I believe his employer had handled that part of it. I don't think he was qualified for any of the exceptions, but he did have to leave, I believe, until his program ended in June 2023. I think he may have had to leave for a little bit, but essentially he was pretty much uninterrupted because the waiver was pending. Even though it was taking longer than we wanted, fortunately, he was able to start working lawfully without any issues. Then we also showed the medical and emotional issues. So the wife had some health issues, both mental health and physical health, and that her husband had made them considerably better over the years, especially the psychological issues, and they were likely to worsen if she had to raise a child by herself for 2 years. So that was showing that she could not remain here without him. Part 2 was that she could not go to Canada with him. Again, financial and professional reasons. She had a great job in the US. And she would have to leave it. She was there since 2019, had several promotions, salary increases. She had all these benefits, even stock options, and she had made a name for herself. Her job would not let her work remotely, and she would lose all of what I just mentioned because she would have had to quit her job if she moved to Canada with him. And not only that, she wouldn't be able to work right away. So they'd effectively have no income for at least 1 year, because it would have taken at least 1 year for her to get the qualifications needed for her profession to work in Canada. But there was a bigger problem for her, that he's from Quebec and he's lived there his whole life. That's where his family is. If they had to go back to Canada, that would probably be their only option. And fun fact about Quebec is, in order to work in the province, you need to speak fluent French. You need to speak French in the workplace, and she does not speak French at all. So that would have been another barrier for her to deal with. And she also had a second job. She had her own business that she had started, that she actually had some a local reputation, a local fame for, if you will. She was in a local magazine and she was trying to get that off the ground. But again, in Canada, no one would have known anything about it, and her business probably wouldn't have taken off. We also showed the medical and emotional reasons that she could not go with him to Canada. She's pregnant, and this was a very big reason. She's not eligible for Canada healthcare as a US citizen and not a Canada citizen. And she had a very difficult pregnancy, unfortunately, so due to some of her physical health conditions. So she needed to be checked and monitored even more regularly than a normal pregnancy. And I'll talk about the evidence in a second, but we did look it up, and it would actually take 17 months for her to get citizenship in Canada. And until you get your Canadian citizenship, you can't get healthcare up there. So that was a big problem for her. And also, the child was born in January 2023, fortunately healthy. But, the child needs a lot of vaccines and everything. And the child was born in the US and would also not be eligible for healthcare until the child became a Canadian citizen. So, in my opinion, very strong case. And when I say very strong case, don't think that it has anything to do with how long it took. I think the last time I talked about one of these, it took even longer, actually. And we didn't get a request for evidence in this case, which, when they take this long, they want to get updated evidence a lot. So I was very happy about that. So what evidence did we submit? Well, we had to show that he had a qualifying relative. So we submitted his marriage certificate and his U.S. citizen wife's passport, U.S. passport. We submitted some joint marriage evidence, even though we weren't filing the marriage petition yet. We could have filed it already. We were kind of waiting to see if the waiver was approved. My clients wanted to wait because they knew that it was rare that they did get approved, although I was very confident. But we did submit joint leases, joint taxes, joint checking account, proof that she was pregnant, because at the time she was still pregnant. If we got a request for evidence, we would have submitted the birth certificate, of course. And then for the extreme hardship evidence, we had really detailed affidavits from both of them explaining all the factors I just mentioned and more. We had letters from the relevant doctors. I put in a provision of the Canadian Healthcare Act to prove that her and the child would not be eligible for healthcare until they gained their citizenship in what took approximately 17 months. We put in the wife's resume, proof of her employment and her benefits, proof that her employer would not let her work remotely in another country. So we actually put in the employment policy. Evidence that it was mandatory in Quebec to speak French in the workplace, because they don't take anything on confidence. You have to prove everything that you claim. Job search showing that the qualifying relative would not be able to find even if she could work immediately, couldn't find a job that paid even close to what she was making here, because she would lose all that promotion and salary and benefits, and she had the type of job that makes more money here. The cost of infant daycare showing they needed to be working in order to pay for it. Evidence of that company that she had started. Her U.S. citizen family ties in the U.S. Even though they didn't live nearby, they were still in the U.S. and they did see each other on a regular basis. We had pictures of them going back and forth visiting. And then the applicant's immigration history and identification. So we had to submit his certificates of eligibility for the J-1 program showing he was in status the whole time. And of course, his passport, visa, I-94, and entry stamp. So really excited for these clients. Now, one thing just to note about these J-1 waivers that are a little confusing. Who actually decides them? So you have to apply to the Department of State and USCIS. And it's a little confusing because Department of State waits for USCIS to kind of go through it. Then they send it to Department of State. Department of State decides, okay, we recommend approval. Then they send it back to USCIS, and USCIS has to make the final approval. So you find out the Department of State approves it, but you actually don't have your waiver approved until USCIS sends that approval notice. Each J-1 waiver is a little different. It doesn't work that way for all of them, but I think that's part of the reason why the process is more drawn out or takes longer. But at the end of the day, it was approved, and that's what matters. So what's next for these clients? Well, like I said, he's going to be applying for his green card. We've already started the marriage petition, and because the waiver is approved, now we can file it all together. So marriage petition, a work permit, a travel document, and a green card application. He is here on his H-1B, so he's allowed to adjust his status from an H-1B without a problem. And he, like I said, and just to clear up any confusion, if he was on the H-1B and the waiver didn't get approved, then he would have to go back to Canada for 2 years before he can change any other status or adjust his status. So I'm not sure. I didn't look if he would have to go home right away, but he would definitely have to go home for those 2 years at some point, unless if he didn't get this waiver approved. Fortunately, not an issue. It's approved. So as soon as we can, we'll be filing that, and hopefully I'll be updating, doing an update video sooner rather than later, saying that he got his green card. But the waiver was the hard part, and the rest should be relatively easy in comparison. So that is all for today. Don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. I forgot to put our contact info on the screen, but you can find that in our profile pages. If you found this video to be helpful or know someone who may, go ahead, click that share or save button and drop us a comment. Let us know what you like, and we'll catch you next time. Thanks for watching.